Every US state runs on the same basic legal system, except one. Louisiana's is so different that a lawyer licensed anywhere else in the country can't just move there and practice. And it's so different that it even single-handedly changed how you do your taxes. So where did this strange legal system come from? The answer traces all the way back to ancient Rome. But before we go there, let's look at the system most people in the US are already familiar with. See, the entire US federal court system uses common law, a tradition it inherited from England. The premise is basically that when a judge makes a decision, that decision binds the courts beneath it to the same precedent. This is how lawyers argue. They say that because a court ruled this way before, it should rule the same way now. When you stack these decisions over centuries, they become the law itself. But to understand why Louisiana is different from this, we need to leave England and the US entirely. Around 449 BCE, Rome carved its first laws into 12 bronze tablets. This was the first time the rules were actually written down for every citizen to see. Nearly 1,000 years later, in 529 CE, the Emperor Justinian ordered all of Rome's laws to be gathered together into a single definitive code. And when Rome eventually fell, the code survived. Medieval Europe rediscovered it and taught it in every university and rebuilt legal systems across the continent on top of it. This system is called civil law. Its core principle is the mirror image of common law. Instead of judges making law one case at a time, the entire body of law is written down in advance in a single comprehensive code. Under civil law, a judge's job isn't to make precedent. They are finding the right article in the written code and applying it to the situation in front of them. This is how the law worked in France when the country founded Louisiana in the early 18th century, and it was also how the law worked in Spain when they took over the colony in 1769. By then, generations of Creole families had lived their entire lives inside that system. It was how they married, how they inherited things when somebody died, and how they owned property. Then in 1803, Thomas Jefferson made the Louisiana Purchase, and overnight, this deeply European place became American. To run the new Louisiana Territory, Thomas Jefferson sent a 28-year-old Virginian named William Claiborne, a man who spoke neither French nor Spanish, to Louisiana with an assignment to convert Louisiana to American common law like every other piece of the new country. Locals had other plans. The Creoles controlled the legislature and they pushed back hard. In 1806, they passed a bill declaring that the old law would stay in force and Louisiana would remain a civil law jurisdiction. When Claiborne vetoed that law, the legislature dissolved in protest, and they commissioned 2 attorneys to write Louisiana its own civil code. The result is the Digest of 1808, the civil code that was locked into place and remained with Louisiana when it became a state. Today, Louisiana's legal system isn't just civil. Only the private law covering things like marriage, property, inheritance, and contracts runs on civil code. Its criminal courts look a lot like everybody else's. And on any question of U.S. federal law, Louisiana judges are bound by the Supreme Court, just like other states. The deepest difference is subtler than you might think. In the other 49 states, a single past ruling from a higher court binds a judge in a district court to that ruling. But in Louisiana, no single case binds in the same way. Instead, a long and consistent line of decisions becomes persuasive over time, and the written code always comes first. In practice, this produces a state that feels legally very foreign. Louisiana has parishes instead of counties, left over from the Catholic colonial past. It recognizes the usufruct, a Roman concept that lets one person use property that someone else owns. And marriage is community property partnership by default. So what you earn during a marriage is owned by you and your spouse 50-50. Another big difference is forced heirship. In Louisiana, you can't just cut your children out of your will, at least not the ones who are under 24, can't take care for themselves. The idea that your family has a claim on your estate, whether you like it or not, comes straight from Roman law and exists like this nowhere else in the country. All this uniqueness lands hardest on lawyers. Louisiana has the longest bar exam in the country, 21 hours long, spread across 3 days. It's the only state that hasn't adopted a standardized national exam, and it offers no reciprocity. So any attorney who wants to practice in Louisiana has to learn a second legal system from scratch and pass the Louisiana State Bar. Brings us back to your tax return. Remember the community property that I mentioned? You have a 50-50 split of property in a marriage. In 1930, the Supreme Court of the United States ruled that couples in community property states like Louisiana could split their income between both spouses and drop into lower tax brackets, paying far less than identical couples one state over. The advantage was so big that other states started rewriting their own laws to copy it. By 1948, Congress gave up resisting and let every married couple in the US file a joint return. So yeah, the married filing jointly option on a tax return only exists because of Louisiana, because of France and Spain, and ultimately because of a set of Roman tablets 2,000 years old.